Okay, all right. Well, keep working on that little quiz that's in front of you. I'm just going to make a few announcements as you continue to work on that. There is this painting that a friend of a family made is the prize for the best score on the quiz. However, Charlotte, is that your name? Yes. Charlotte really liked it. So if you happen to win it, know that Charlotte really likes it.
She's trying to get rid of stuff.
Yeah, you might. So most of you, I take it, are from this church community. Is that right? Yes. Do we have any folks that are not from the church community? Okay. Are you from Adkins area? Okay. New Braunfels. How did you hear about, word of mouth, eh? Okay. Well, Pastor Brett, you want to raise your hand in the back for the folks that are visiting? There he is, sitting on the arm rail there. There's snacks and food in the back kitchen area. Feel free to get up and go as you like. And then the bathrooms, are around the corner, or is there a sneaking path over here? They got to go around the corner to the bathrooms? Okay. So now you know where you're at. Feel free to get up and go as you like. Feel free to ask questions as I'm talking and going through the seminar. It's not a me talking to you. It's a Q&A back and forth, okay? Your questions probably are somebody else's questions. What else? I am appreciative that you guys are here Saturday morning when you could be working in the garden or watching TV or sleeping, eating breakfast somewhere. Appreciate it. But I think you're going to get a lot of good information. I know you're going to get a lot of good information out of the seminar. And that's the whole point of it, is to give you information. My mom told us children that knowledge is power, and we all have heard that before. Knowledge is power. So my hope is to give you power by giving you information, helping you to informing the decisions that I hope you'll make. And if you've made some estate planning decisions already, I think some of this information is going to maybe cause you to rethink or add to what you've done. So thanks. Can I call you Pastor Brett?
You bet.
All right. Thank you for inviting me to come here. Do you want to come up front and say anything, or you don't have to? Pastors always get put on the spot. Maybe we can just do an opening prayer, quick opening prayer.
Hey, thanks for coming out today. We're tickled to death to have Sim and his family with us. Wonderful, sweet family, Mallory, Claire, Henry, and Lucy. They're just wonderful folks already got to know them. Paralegal here.
Cherokee.
Got your name?
Cherokee.
Now I know it. Got it like a steel trap in my mind. Okay. But glad to have you out with us today. We met online, and so we don't know a whole lot about each other. This is the first time we've seen y'all face to face here this morning. But I'm looking forward to what Sim's going to give you here today. So many of the folks that are here have asked me questions about different parts of this, estates and wills and trusts and all of that sort of thing. I don't know if you realize it or not, but when you are a pastor, you become an attorney, you become a doctor, you become all kinds of things with the people that you church with. So, and rather than give people bad information, I decided we needed somebody that could give information that was worth a hoot. And so we bring that, amen. So we got Sim in today to do exactly that. Here's what I'm going to do. I'm going to pray. I'm going to get out of the way and let Sim do what he does. Is that okay with y'all? Let's do it. Dear Heavenly Father, we thank you, Lord, for the opportunity that you've given us to get here this morning. I thank you, Lord, for how you put it all together, and the people that are needing to be here are here. Lord, I have no doubt of that. You have worked in this situation. We prayed about it. You know what everyone needs and where they need to be. So, Father, we're trusting that this is a divine appointment that we have today. I'd ask you, Father, that you lead, guide, and direct everything that's said and done here today. Lord, that you be glorified in all things. Amen. Father, that we move ourselves out of the way and look to you for the answers of life. God, help us to plan and be wise in that area. But Lord God, to understand that you have the right to do what you want with our lives. Yes. So Father, we try to walk that balance today. Lord, to plan and be wise as serpents, yet harmless as doves. So we ask you, Father, for your presence here. Thank you, Lord, for the information information and the friendships that will come out of this. And we ask you, Father, to do that because we believe you can, and pray it in Jesus' name.
Amen. I'm going to ask my family to the front row because I'm going to introduce you guys in a minute. So come sit up front, kids. Cherokee, would you stand and raise your hand? I guess some of you met Cherokee as she came in. And so she's paralegal on my team at the law office. So if you need to ask her questions or talk to her, have a seat, kids. That's who she is. Have a seat up in the front, okay? I'll call you up in a minute. So if anybody's married, a business owner, divorced, has children, has lost somebody, has somebody disabled in your family, you're right. This seminar is going to be for you, right? It's for everybody. But those kinds of life circumstances often cause people to reevaluate what their estate plan looks like. And just to get it out in the open, the estate planning is not just for wealthy people. A lot of people believe estate plan is for rich people. Everybody has something. You have a small estate, medium, bigger estate. Everybody has something, from your banking, your cars, your house, your furniture, the inheritance you might receive one day, lawsuits, you're involved in a car accident lawsuit, that's an asset. All those things form your estate, and so everybody needs to plan ahead for that. So don't let the word estate planning make you think, I can't afford this. I can only go to the free seminar. I don't want you to think that. Everyone needs one. Everyone needs an estate plan. Even that kids that are going off to college and this month, they need something put together as well. What's the cue? You just want me to do a thumbs up or something to let you know when to go to the next slide? Or I can say next slide. So today's title is Stewarding Your Assets, Protecting Your Family, Leaving a Legacy. And you can go to the next slide. A little bit about myself, because most of you don't know me. I'm an attorney since 2007. I went to the University of Notre Dame for undergrad. I worked with Senator John Cornyn for a couple of years, 1 year actually, before I went to law school. Did well in law school, and I got a clerkship, federal clerkship in Laredo, Texas, with Judge George Kazin. He was a brilliant guy, brilliant man. Talk about graduating college, I believe at 18, law school by 21, and the top bar scorer in the state of Texas when he took it. He was appointed by Judge Carter, President Carter, and served for a very, very long time, but he passed away a couple of years ago. But he was a great mentor. Then I left his office to consider becoming a Catholic priest. So I spent 2 years in the seminary in San Antonio. So that tells you I'm Catholic. Don't think bad of that. We're all in the same camp here, believe it or not. And I left seminary after 2 years, and I started my practice in Selma, and then Schertz and Cibolo, and then back to Schertz. So I'm in Schertz on Schertz Parkway. It was about 15 to 20 minutes from your church here. We can go to the next. I want you to know about my firm and how I think and how I approach and how I do work. And we are a purpose-driven firm. You've heard of that book Rick Warren wrote, A Purpose-Driven Life? I stole a little bit of that, and I said, we're going to be working on purpose-driven planning for people. You guys come in, or people come in with a purpose in mind of protecting the people that you love. People is one of the first things you think of. And promoting your legacy or the values that you have. For me, we're a Catholic Christian firm. I'm Catholic. The other attorney's Baptist. We have 2 non-denoms in the staff. We are a Christian firm, and that's part of our purpose and our mindset. And so we want to help people to incorporate their values, their faith, into their planning so we can protect the people that they love. What's our basic mission is to help everybody get their final affairs in order. Final affairs in order, meaning, from the legal standpoint, wills, trusts, powers of attorney, long-term care insurance. I don't sell it, but I recommend people to have it. We talk about different aspects of planning, accounting, savings, retirement, insurance. Kiddo, can you sit down? Sit down, please. All kinds of things. We're trying to point out all the issues you need to know about, and then we do the legal side of things. getting your funeral plan, getting your plot, deciding on those final services. So that's mainly what we do, but we also handle business establishment, like if you're going to start an LLC, or auto accident, personal injury, if you hurt yourself, get in a crash, we can also assist with those things. And probating. When people die and they have a will that needs to be probated, we can help with that. So let's go to the next slide. I mentioned, well, we can skip that one because really I already told you why I'm here, is to give you that knowledge and that education so you can make good decisions. And I would guess you're here to get that information and get that knowledge, right? Okay. We can go to the next slide. Okay, that could be a motivation to come to something like this. Sometimes you hear of a bad story. Somebody you know has gone through a rough time, and you say to yourself, I don't want to go through that, so I'm going to get my affairs in order. And so that's a good reason to be here. I'm going to pause there, and I forgot to introduce my family. I was like, where is it on the slide? But I passed that slide. So kids, will you come up? And Mallory, yes, come on, Mallory. Sorry. This is my wife, Mallory. She's good with cats and dogs. She's a veterinarian at, where? City Vet? I know that already, but I'm up here on stage. So City Vet, Alma Heights. This is Claire, right? Claire, you want to say your name in the mic? You want to say it in the mic?
Claire.
And your name?
Henry.
Name?
Lucy.
And I'm glad that you're here helping today. And thanks for all your help. Now go sit down. You can go in the back. 7, 6, and 4. All right. Talking about purpose. Those are the people that are important to me. That's part of they are the main people in my plan. But so is charity and charitable giving. So 10% of what I have is going to the charities that I support during my lifetime. And I really do hope and encourage that people always include charitable giving in their planning. I can tell you, sitting on this side as the lawyer, that most people do not. Most people say, I've already given during lifetime. I'm going to give all this to my children. And I still encourage them to, okay, consider it anyway. But you can give more when you're dead and gone, right? Because you can't take any of that with you. So you can give a whole lot more when you die. So I hope that if I meet with any of you, I hope that you will be different than the other folks that I've met with, okay? And I will, I just really encourage that, right? Okay. You'll see why when I get to a certain slide up ahead. Let's go to the next slide. Here's sort of a horror story that I encountered when I first started my practice about 12, 13 years ago. There was a family from my church who had, there were 10 siblings. 7 had already passed away. I was talking to the 3 of them. They were concerned about the family home that they grew up in on the east part of San Antonio. It was a good big lot, big country lot. And they wanted to know how could they sell it or control it or have title to it. And after I did research, I found out that nobody had wills, mom and dad. Nobody probated. You can probate in court whether or not you have a will. Nobody probated, and out of all the 7 siblings, it was the same thing. Nobody had wills, nobody probated, nobody talked to lawyers, nothing. Nobody did anything. So lesson 1 is, when somebody dies, talk to a lawyer to find out what steps need to be taken to transfer title out of the dead person's name into the living people's name. You have to do that. And I won't say more on that, but my research turned out that there were 27 different family members who owned this one home, and they were spread throughout the country. And I said, for us to do the probate, we've got to figure out the heirs and the estates of all these different family members, not just one, all of them. That's a lot of money and time in court. A lot of witnesses are dead and gone. And once we establish that, we still have 27 owners that we have to corral and get on the same page. And we made one call to the folks from New York, and they were very unfriendly. They did not want to work with my clients. And I was like, well, if we can't get them, it doesn't matter if we get everybody else. You can't just have part of a house. You need whole title to the home. So I think the end of that is that the house just sits there Once the county doesn't get their taxes out of it, they're going to come seize that and auction it off. I don't know if that ever happened. I haven't looked into it, but it was just unaffordable for them to go further. Yes, ma'am.
Questions when this comes up, or do we wait to the very end?
No, you don't have to wait till the end. You can pop a hand up.
If someone dies without a will and no children, and man and wife, they die without any children, no will, and they have a home and they have acreage. Okay, husband dies, the wife, of family members taking care of her, she's in the nursing home. She lives to be 90, she dies. And of course, the state wants to get the money they put out in the nursing home.
You're talking about Medicaid is wanting to get some reimbursement.
Is there any way, and say there's two siblings living, but would that property just remain until whatever the state decides, or again, no will, nothing? What is the best, that one of the family members has been paying taxes on the
Well, that makes the county happy. They'll get their taxes. They won't bother the family member. But as far as Medicaid goes, they're still not happy. They can file a claim, and they would file a claim if there was a probate estate opened. I don't really know what happens, what Medicaid does when there's no probate estate opened in court, because when you open a case in court, they file a claim against it. But if you don't open up a case in court, I don't know what they do. They probably are going to file some type of lien into the deed records against it. I would suspect they do that because they have a right to reclaim. And so the family members own the property by law. They're the heirs, so they own it from date of death forward. But it is subject to any debts that the deceased left behind, including Medicaid. So Medicaid can still get involved. And if there's any money left over at some point, that goes to the siblings. If they have to sell the home, Medicaid gets paid, the siblings will get what's left over. But if Medicaid's not bothering them, because they don't know what to do or who to call, well, they just keep paying the taxes, keep using the property, keep living in it. I just wouldn't invest too much, repair or money into it, because you could lose it.
But just live there. They can
Yeah.
keep living there as long as
They own
pay
it.
tax, right?
They own it, yeah. They would have to do an affidavit of heirship at minimum. That's the legal document they need to establish their rights to the home, because it probably still is in the name of mom and dad. And that's what the county thinks still lives there. So you need to do it. They need to do an affidavit of heirship to transfer the name over.
Thank you very much.
Ricky?
Does the Lady Bird title block Medicaid's claim?
It does. So if the mom who was using the nursing home while she was alive had signed a Lady Bird deed, then Medicaid would be out of the picture.
What is a Lady Bird deed?
Anybody know what a Lady Bird deed is? Cherokee, the paralegal, she knows. Do you want to answer that? No, I'll answer that. Lady Bird deed is essentially transferring your real estate upon death. Transferring your real estate upon death. It's a deed, which you need for real estate. It's a conveyance. You're giving away an interest in the home. You're giving it away to the kids or the spouse or whoever. And you're retaining back for yourself a life estate. As long as you're living, you have rights to the home. Once you die, 5 days later, it becomes the grantee's home. That's the Lady Bird. In the weeds, I'll get you into the weeds for a moment. The reason why Medicaid can't penalize you for doing that or go against it when you die is because it's not yet a completed gift until 5 days after you die. And since you have rights to the home, you can change your mind and sell it. So it's not a completed gift. Medicaid will penalize you for making gifts, giving away your assets to become eligible. So they don't want you to do Lady Bird. They don't want you to give away stuff. But Lady Bird is not a completed gift. But then once you die, 5 days later, it's no longer part of your probate estate, and they only have rights to claim against your probate estate. So they can't come against non-probate assets. They can't do that. So if it's in a living trust, if it's in a living trust, No, it has to be, yeah, if it's in a living trust, they can't get it, but you don't want it in a trust if you need Medicaid. You have to take it out of the trust for Medicaid. So I think mostly answers your question and your question. It does block Medicaid. You have a follow-up?
Like follow-up. So if you do nothing and there are no heirs, the relatives have no responsibilities to the property.
No, it's like your situation is like her situation there. The heirs inherit the home by law. So you're going to inherit your brother's home by law. And so your ownership of the home is still subject to any debts or claims of creditors that your brother had or the deceased person has. So they could still come asking for Medicaid, could still come asking, pay up. Not against you, but against the property. Okay? Not against you.
But I wouldn't have to assume ownership of the property
You actually are the owner of the property. The moment,
just because I'm a brother.
yep. The Estates Code, section 100, 101, it says, on the date of death, all the heirs at law are vested title in the property, subject to the debts of the deceased. If there's a will, however, that gets probated, then it's the will beneficiaries who are vested at law in title, still subject to the debts of the deceased. So in your case, you'd be subject to the debts. I'm going to move on. Did you have a question?
You mentioned affidavit of heirship.
Yeah.
Does that apply to a home as well?
Yes, it's really only for real estate. Really for real estate.
Because I had to do one of those for a truck.
Yes, that's the DMV's affidavit of heirship.
Okay.
So we don't do those, the DMV does those, but the ones lawyers do is for real estate.
Okay. And then if an heir decided to say, I want nothing to do with it, signed it over, and stated as such, we had it notarized, then I can go ahead and proceed with the sale of the house.
Was that before death or after death?
After that.
Has to be written in a certain way, and
But it has to be written a certain way.
that kind of,
Conveyance of I don't want anything to do with
that statement of I don't want it, it's a disclaimer really. So it either has to be a valid disclaimer, or it can be a quitclaim or a gift deed or some type of deed where they're giving away their rights.
So the attorney I was working with said that she just needs to write something up and saying I want nothing to do with it.
That sounds like a disclaimer to me. It's just got to be done within a certain period of time, 9 months after death. And
Is it 9 months after death?
typically, I believe that's the rule.
After death. Okay, so
Yeah. So that sounds more like a quitclaim, probably. Quitclaim deed. Don't use quitclaims generally, but the legislature just kind of allowed them, so that's a revised statement. But sounds like a disclaimer. And if you don't want something, you can also just deed back to your siblings what you didn't want.
So I'm getting ready to sell my house, and that's what I have. I have affidavit of heirship, and I have a quick claim. So
Yeah.
do I foresee problems? Probably, right?
If you want to show me the paperwork in an appointment, I can look it over and tell you for sure. Otherwise, title companies are pretty good at telling you if that's going to work or not, or what you still need to do.
And I need to do this before I list the house.
Probably, yeah. You don't want to have delays when you're in the marketing process. Let's go to the next slide. There we go. Pop quiz. Were you wondering when I was going to get to that pop quiz? All right, so let's look at that. I was wondering too. Where's that slide? There it is. All right, so we're going to test your estate planning smarts. So raising hands, speaking out answers. You don't have to raise your hand in this class, all right? You can just yell it out. About what percentage of people ages 18 and up, that would be adults, currently do not have a will? And we're talking about the state of Texas.
84.
You're pretty close. It's actually 64%. All right. Most statistics say about 65% of folks don't have a will. And if they don't have a will, they probably don't even have powers of attorney either. Because most people are thinking wills and not thinking anything else. Number two. So I wonder, maybe 64% of this crowd doesn't have a will? We'll see. If you're not married and you don't have children and you don't own property, then you don't need to worry about estate planning. Right, it's false. Because you need to plan for your lifetime Should you become in an accident, sick, incapacitated, ill, needing help, you need to have powers of attorney at least. Okay, so you don't have to go through guardianship proceedings. So don't just think about dying, think about the rest of your life when it comes to planning. And a lot of people just think, hey, I just need a will. I hear that call a lot. I just need a will. I have a simple estate. It's only $5 million. I hear a lot of that. Who decides what happens to your assets if you die without a will? Perfect. That's right. The Texas Estates Code is the law. The Texas Property Code, the Texas Family Code, and a couple other codes all play a role. But it's the probate courts. Have any of you ever been through probate court? Yes. A couple of you. So Bexar County has 3 probate courts and 2 or 3 associate judges. That's about 6 judges that are all just handling the death or the incapacity of somebody. It's a lot of work. That means a lot of people are going through that. And it is. It's a lot of... Anyway, so they handle that. 4, you need a will to make sure the money in which of these accounts goes to the heirs of your choice.
I put none, because can't you put a beneficiary on all of these?
Yes. E is the right because you can designate beneficiaries on just about everything financial.
You should be able to.
So when I meet with people, when I tell everybody, you better have POD beneficiaries, right of survivorship between joint husband and wife accounts, put it on your car, put it on your banking, designate your insurance, your retirement. Usually it's real estate, personal property that probate is dealing with, because you can plan and prearrange all that other stuff. But the real estate in Texas is usually what brings a family in to a lawyer or to probate court. So I help people to deal with those things, avoid probate court anyway. So that's our goal, is to keep people... I forgot to mention on the slide, our goal is to help everybody stay out of the probate court system, if we can, most time we can, to streamline the process for people. You don't want to leave your family members expenses, hassles, procedures, if it's all avoidable. So most of it's avoidable. I help you get there. Prearranging, just doing a bunch of prearranging. That's why we call it planning. We're just planning things. Yes, ma'am.
If you have a will, giving your house to your children, do you still have to do probate?
Let's see. That's question 6, right?
I didn't even know.
If you die with a will, your heirs can skip probate and your financial life will remain private. False. So to answer your question, big misconception. Probably 50% or more of people think, I've got a will, I'm done. I die, I'm good. Don't need to see a lawyer, don't need to go to court. Wrong. Wills, every single will says in there, in one little hidden sentence, nothing, my executor has to do nothing except for probating the will in court. Or nothing other than probating the will in court. Most people don't see it, but that means the will must be probated in court. Then your executor gets appointed by the judge to serve in that role. Then they get official paperwork to go to the bank and go, I represent the estate, give me the money. I represent the estate, let me sell the home. I represent the estate, let me transfer the truck title. So you need letters testamentary as an executor, or you're not the executor. And if you never go to court with that will, the will did nothing. Did nothing for you. However, it's confusing because most people, because of beneficiary designations or survivorship rights, they actually end up getting most of the assets. They get all the financial assets in the survivor's name, and they assume that they go to the tax office or the appraisal district, and they always tell the surviving spouse, well, okay, give me a death certificate, and now we put it under your name. And so the surviving spouse thinks that they have 100% title to the home. They don't. They just have 100% responsibility for the taxes. to pay. And the appraisal districts they're not lawyers. They don't determine title. They're not courts. They don't follow the code exactly. They do their best, but they can be wrong. So, but they often tell wives that, hey, thank you for letting us know your spouse passed. We'll take his name off and put your name on the tax bill. So you see your tax bill in your name. But it doesn't mean you own 100% of the home. So the will is one method of transferring the title out of dead person's name to surviving person's name. If you haven't probated the will and you thought that you didn't have to, I'm now giving you surprising news, okay? But it's true, it's the fact. Yes, ma'am.
We want to mention the beneficiaries on the banks.
Mm-hmm.
Because my husband back in 2013, I don't know if anything's changed, but Wells Fargo is horrible. And my husband was on the account to pay for all their bills. And when they died, they never assigned the beneficiaries. So even though his name was on the account, he was a third person. My father-in-law, my mother-in-law, and him, they were on the account. They would not let him take any more money out once they died.
They froze the account?
They froze everything because he wasn't assigned.
Has anybody else heard of that?
So be very careful with that. I don't know if that's still true today.
It's still true today.
I
What's
just assume Wells Fargo is terrible.
No, they're not.
They are,
Maybe for other reasons, but they're just following their procedures.
Yeah.
If you have 2 or 3 or 4 people on an account, it's a joint account.
Yeah.
And you can have joint account with right of survivorship or without right of survivorship. This one did not have right of
I
survivorship.
didn't even know that that was a thing. It was just like, oh, he put his son on there, no problem. He has access to it.
So the didn't know that. The customer didn't know any other way. But when you open an account, the bankers usually, they give you a form with some check boxes, and one of them says, with right of survivorship. And if you check that box, then that wouldn't have happened in that situation.
Yes. And it was really important, I say this, because when we went through, unfortunately, one of my sister-in-laws started a big lawsuit in the middle of all of it, and there was no access to any income in there to, like,
To fund the lawsuit,
for
to
my
defend.
husband to get stuff done. So we had to take it out of our income and then repay it. And so sometimes that can be a problem for people because they don't have the money to get things done, and you can't access that
Yeah.
account.
That's true.
So, yeah.
So rights of survivorship on joint accounts, not for everybody, but definitely for husband and wife, yes. But not every situation.
Back to the probate, when the lawyer does your will, and they say, with the work they've done, which I don't know, I'm not all familiar with legalities and so forth, but they say you will not have to go to probate court. Is there something specific?
When you have a will and somebody says,
When that
the lawyer says,
complete will, and they say you won't need to go to a probate court because of, I guess, the will that they've done. Is that possible, or are you saying?
yes, it's possible because some people will not have any probate assets to deal with. And my grandma was an example of that. So if I drafted a will for my grandma, who didn't own any property other than her clothing and jewelry in one bank account. The bank account had right of survivorship already, so that's not probatable. So it's just her personal items. But I wrote her a will anyway. Everybody should have one. And I could have told her, you probably don't need to probate this will when you die. No one's going to probably need to probate this when you die. Because she didn't own anything that needed to be transferred out of her name. So in that circumstance, the lawyer would be right. But if the lawyer's trying to give people impressions, if the lawyer's doing it out of those circumstances, that would be wrong.
Okay, so it's always wise to take it to probate.
To a lawyer. Meet with a lawyer. At the time of death, survivors go to the lawyer and say, do I need to probate the will or not? Let's figure out what the circumstances are. And sometimes yes, most of the time yes, sometimes no. But if you can plan ahead of time, most of the times no. Right? So we try to keep you out of the situation. Let's see. Number 5. Federal estate taxes can claim as much as 40% of taxable assets are an issue for individuals with estates worth how much in 2025? It should say 25. What do you guys think? Who? What? D? D's the biggest number, right?
Yeah.
14 million bucks or so? Is that what I have on there? Yeah. That's the current exemption for lifetime. If you die with less than $14 million of value, including your insurance policies and whatever you POD to somebody, that all gets pulled back in, you add it up. If it's less than 14 million, you don't have to file a federal estate tax return. Not talking about income tax, talking about estate tax. So that's an exemption. So we're going to have some slides on that, but that's a result. That's a pretty generous exemption. Most people don't ever have to worry about paying a death tax, an estate tax. But Bill Gates will, Donald Trump will, George Soros will, like all these big wealthy people, they have 10 lawyers or 100 lawyers figuring it out to avoid the taxes. Estate taxes, number 7, estate taxes and inheritance taxes are the same thing. True or false? False, you're right. So we just talked about the estate tax. That's what the dead person has to pay to Uncle Sam or to the state. And then the inheritance tax is what the recipient or beneficiary or the heir has to pay. And in Texas, do you think we have an estate tax? We don't. Do you think we have an inheritance tax in Texas? We don't. Texas is a promised land, right? We don't pay many taxes here. But New York, California, Oregon, Pennsylvania, Maryland, some of these other high-tax states, they'll tax you when you die. They'll tax the beneficiary on what they get. They'll tax your income. The federal government, they have the estate tax. We just talked about the $14 million, so they have an estate tax. They don't charge taxes on inheritance, though. So federally, no tax on inheritance. A lot of people ask me, will my children have to pay tax on what I leave behind? In Texas, the answer is no.
So there's no inheritance tax, but if you say you inherit land and then you sell it, then there's a capital gains that kicks in, right?
Correct. If you sell it right away after death, you probably don't have any capital gain because when that person died, the cost basis jumped up to the current market value. Then you turn around and sell it, there's no gain. You have expenses to pay. But if you wait 2, 3, 4, 5 years, then that land's appreciated. Now you're going to have some gain. Tax to pay.
So you don't have inheritance, but possibly the
Capital gain tax. And if you inherit an IRA or a 401k and a retirement plan, and those are producing dividends or income, and you pull out the money, you're going to pay income tax on that. Just like the dead person would have paid when they got the money. You still pay income tax on that because it hasn't been taxed yet. So the government needs to tax the income you're getting, right? Which of the following documents do you probably need a lawyer's help to draft? I'm on number 8. A, B, and D, but not C. So that's the last letter. So let's see. You probably need a lawyer for the will, the trust, the religious, faith-based advanced directives, medical directives. But most hospitals have a fill-in-the-blank medical power of attorney. WellMed has them, Base has them. If you're privy to JAG benefits, you can go to the JAG office and get a lot of free stuff there.
What is that? What is D? I've never heard of D.
D, an advanced directive.
Yeah.
Yeah. So Texas legislature has a standard form for the medical power of attorney, financial power of attorney, and medical directive. Sometimes it's called a living will. And that determines when you're terminally ill and you can't speak anymore. It tells the doctors how much treatment to provide or really when to stop treating the life of a person. So no life support, no food and water, no surgeries, no this, no that. It's a directive telling them to withhold treatment because you're near death.
Well, it's like Jehovah's Witness. They can't have blood transfusions.
That's a particular instruction they want to have in their directive, so that's gearing towards their faith.
Given to the doctor.
Yeah.
My secretary did that.
So all Jehovah's Witnesses have to have a faith-based directive that incorporates their belief.
That's just an example.
So the state of Texas directive does not incorporate a traditional Judeo-Christian ethic into that standard form. So beware, if you're getting that free one from the doctor's office or hospital, it very well might put you or your family in that ethical quandary at some point. And so I don't recommend people to use the state directive form, so I produce faith-based forms. And in the back, there was a handout. I think most of you grabbed it. It had SBC guidance on living wills. That's one slide I printed out from the presentation. I did do a little research on what the Southern Baptist Convention has to say on living wills, health directives. And so that's a very short summary, and there's a resource or a source reference there. They did publish a document. It's online. You can read it. Pastors can read it and learn a little bit more. It is very, very much in line with the norm of Judeo-Christian teaching. So I do a lot of Catholic wills and directives, and we're meeting eye to eye like on 98%. So very similar, because we're drawing on the same Jesus Christ on this stuff. So it's very, very similar ethic. What changed is in the 60s, 70s, and 80s in this country, you had a death with dignity movement arise. And these folks were saying, I want to have autonomy and to decide over myself, and I want to decide when I can stop treatment, and I want to decide when I can die. And that thought goes a step further to euthanasia or assisted suicide. I want to stop suffering, and I want to go out of the world. And so in several states on the West Coast and in Canada and in Europe, it's legal to to kill yourself by injection. Okay? There's a whole lot of problems with that. But those people lobbied for this living will directive throughout the 50 states. So there's a more pro-death bent generally speaking, there's more of a pro-death bent on these living wills throughout the states. And so you have to read them very carefully. All the different church leaderships, different denominations, the leaders are saying, be careful what you sign, because this is a pro-death document usually. It's coming from that group of lobbyists and activists. We Christians have to be mindful of what is being said in those and amend them or change them to conform. Most lawyers aren't going to do that. They're going to give you the state form. But I'm a purpose-driven firm. I'm a faith-driven firm. So we're going to provide you options, different options. Number 9, people with assets in which of the following forms should probably consider a trust? What do you think? Yes. Mm-hmm. D, a vacation home in another state. So anytime you have real estate outside of your home state, you really need to consider a trust. Why? You die in Texas, you have a will, you got to probate the will here in Texas. If you have real estate in California, you're going to have to probate the will again in California. So now you have 2 probate courts, 2 probate lawyers, and they have a lot higher fees than we do have here. So a trust, you would set that up, put your 2 homes in the trust name. When you die, there's no probate required for the homes. So you saved $25,000 to $50,000 in California, and you saved a mere $5,000-6,000 here in Texas. But that's worth saving. So trust is helpful. Number 10, you want to update your wills very frequently or at least every 2 years. True or false? Not really. It's just kind of based when life changes. When does life change? Means maybe some of the people I've named needs to change. I got married. Somebody died. I retired. I got a job. Whatever. I had a baby. Had another baby. Had another baby. Had 7 babies. Yeah. Who in here has the most babies? Brett does? 9? Biological or adopted? Both? One at a time. All right. I'm the youngest of 7 boys. My mom had 7 boys. She's mentally ill now. Can you understand? Number 11, how much money can you gift to a person or place every year without paying income taxes or taxes of any kind? 19,000, that's the number. Yeah, 16, 17, 18, now it's at 19. Next year, I think it goes to 20. So you can give away $19,000 of asset or cash to an individual person or to a church like this or to a school like that and not have to declare it to Uncle Sam. But $19,002, you got to declare the $2 to Uncle Sam and get taxed on it. But you have a $14 million exemption, so that $2 is 2 of the 14 million, so you don't pay tax on it. You just have to declare it. You file a return. So you pay the CPA the money for the return. So there's work. So keep it under 19. That's the
Sam?
Sim.
One last question on estate. When, of course, here's your estate and your heirs are getting it, if you have an automobile there, when these people get the estate, but there's an automobile there, is that included automatically in the estate? Or do you have to specify who you want to give that auto?
In the will, you mean? You're saying it in the will? Or just if you have no will?
Well, you state who the will, your estate is going to.
Uh-huh.
You've got that in place. Well, you've got a car sitting there.
Uh-huh.
Is that car part of the estate, or do you have?
Generally, yes. Yeah, generally everything you own in the world, by default, is part of your probate estate until you make some type of prearrangement to remove it from the probate estate. So your car would be included unless you had put right of survivorship on it or beneficiary designation on it or put it into a trust, you know? All right.
Thank you.
Hold on for 1 second. Let's conclude the quiz. We've spent almost an hour on this portion. I haven't even got into the first half of the slides, really. So I'm gonna breeze through, hopefully breeze through some of the slides. The first half of my presentation is the longer half. The second half is 15, 20 minutes. So we haven't really got into the main part of the first half. Do you have a quick question, or you want to hold it for a little while?
A quick one on the last number 11.
Okay.
Is there a specific form you file every time you give more than 19,000?
Yeah, it's a CPA prepared gift tax return. I don't know if TurboTax does it, but I know accountants do it.
Is something you can do?
No, I'm not an accountant, no. My father-in-law is, but there's many others. I don't do those. So who got a score of 11 on this? Anybody get 11?
I probably got the highest score.
You think you got 11? Anybody get 10? I mean, because the high score gets the picture.
I got 9.
You got it?
I got 9.
Who got 9? All right, so whoever can stand on their head the longest between the two of you. No, so 2 9s? 2 9s? Okay. Well, I have one prize, so how are y'all going to work that out?
Pick a number between 1 and 10? I don't know. But you've got to pick it.
Okay, I picked a number.
7.
My number was 7. 7, right on the dot. So you got that. But
You might have to fight Ian.
Charlotte said she got 11, though, so you have to.
Oh, did you get 11?
All right, let's go to the next slide. What is estate planning? That is, to me, it's an act of stewardship, really. It's a bunch of acts of stewardship, but it's putting together a formal plan, a legal plan, to help manage your assets during your life and illness, and then help to pass it at your death. And you can go to the next. In the next. Good estate planning is going to help you stay away of the court system, stay away from the lawyers somewhat, for the most part, save money, save taxes, save legal fees, and save time, trouble, and stress for your people. All right? And the next slide. It will ensure most people peace of mind. I have a lot of people say, I feel so much better now that I got this done. Peace of mind You make sure that the right people get your property. The right people are in charge of the process. If you have somebody who's incapacitated that you need to be taken care of, you can set that arrangement up so you can feel better that that person's being taken care of. Or if you have beneficiaries or children that really shouldn't be touching the estate or receiving any of it, you can keep them out of it. And you can make the process more convenient, more streamlined. We can go to the next. So why is it that so many Texans don't have, why is it 64% of Texans don't have an estate plan? The next slide will tell us that actually they do. They have the government plan, the estates code, the property code, the family code. That's this default government plan. Everybody's got one. And most people don't realize that. They've heard bits and pieces through kind of talk and common wisdom. Much of that common wisdom is actually false, as we learned in the quiz. But if you want a personal plan that fits your wishes, then you got to go be proactive and make that happen. Many people have an incomplete plan. They have done some things, like they designated beneficiary, or they did right of survivorship on a car, but they didn't do other things, so it's incomplete. And then, yeah, people just generally don't think about visiting the lawyer. I don't know why. Why don't people come see the lawyer? We can go to the next slide. I don't hear any of those answers. That's a good one. Why aren't more Texans in better shape? The answers are on the next slide. Oh, well, that's one. People don't like to think about it. Some people are superstitious. They think that if I make the plan, I'm going to die tomorrow. I've actually heard of one person where that was similar to true, but most people, it's just like getting a house insurance, auto insurance, life insurance, medical insurance. You're just planning. It doesn't mean you're going to get sick or get in a car accident or die. But people have that superstition. Some people just put it off, put it off, put it off, put it off. We can go to the next slide. There's a whole bunch more reasons why. Fear. Again, I don't want to think about it. I might die. My kids don't want me to think about it or talk about it. I'm not going to die. That's more what the young people say. I'm going to go rock climbing, jet skiing, jump out of an airplane. I'm going to go fight a war. And they don't think they're going to die. Age, I'm too young. Many are just too busy. I think that's the most thing. Most people are too busy or feel like they're too busy. They're living one day today. Kids, school, work, activities, church. They just put it off. So many people put it off. I have people coming to me at like 70 and 80. I'm going in for surgery next week. Can you get a plan put together for me? And I'm saying, it takes me a few weeks to put something together. Or I'm going on a trip in 2 weeks. Can you get it all done? I don't want to die. And I'm thinking, well, you could have come in like 20 years ago. But ignorance. People thought, I'm married. Everything's going to go to my wife when I die. We're a community property state. Both names are on the title of the house and the car and the bank. It's ours. That's an assumption, but it was a false assumption most of the time. So that I am helping to hopefully correct some of those false assumptions. We can go to the next slide and the next one. So educate yourself, which is what you are doing. Educate your community, which is what you are doing. Tell the people that you know, hey, I learned about something this Saturday. Did you know? And generally speaking, if you're over 18, you need to have an estate plan, period. So you ask people at the restaurant or at church on Sunday, sitting next to them, hey, do you have a will? Do you have a power of attorney? What happens when you die? Hey, what if you get sick? Is somebody going to be able to make medical decisions for you? Or for folks who have little children at home, what if you go out for date night and you don't come home? What's happening to those children? Does the babysitter know who to call? Because the police are going to show up to inform the babysitter that you didn't come home tonight, and that babysitter, 15-year-old, is going to be freaked out. You know, you need to have a plan, and you need to think that it can happen to me. And you have to think about, you know, I always thought that mom and dad would take care of my kids, but they live in Minnesota. I need someone local who can take care of them in the immediate term before my Minnesotans come down to get the kids. So the basic estate plan that everybody would need to start with from a legal point is a will, medical power of attorney, financial power of attorney. 3 documents. That's the legal documents you need. Even the college kid, the young adult, the old person, the person in a nursing home, anybody, will and 2 powers of attorney. One keeps you out of probate court at death. Those other 2 keep you out of probate court when you're sick or unable to manage things for yourself. And then you got to educate, then you got to build your plan. Build it, put it together. Visit with your bank, your financial advisor, your insurance agents, your lawyer, all the different people that make part of the team up. Start meeting and making arrangements.
You said will, medical power of attorney, what was the third one?
I have DPOA, which means durable power of attorney. That's the financial legal power of attorney. So MPOA, DPOA. I might say that again. MPOA, DPOA. And let's go to the next slide. I'm going to take you through 2 fictional people, a family, Bob and Mary, off the internet. And actually, Bob and Mary is my mom and dad's name. There's a little bit of truth to it. That's not them. I'm half Hispanic, so there's no Hispanic there. I'm half Hispanic. To change the slide. Okay, 3 children. Tom, Julie, Steve. All right, got a Catholic priest up there, but he could be something else, right? Episcopal or something. I have a few brothers who fit the category of Tom. I don't have any sisters. Thank God, or I don't know, maybe not, I don't know. I have 2 good daughters, that's good, that'll work. But I have several brothers who fit Tom's category, okay? And there's 2 of us essentially fit Stephen. I have a doctor, the oldest brother is a doctor, and I'm the youngest brother. Everybody in between is kind of screwed up, okay? One way or the other is kind of screwed up. You go to the next slide. Typical families that I meet with in the world, in our community, their house, or they want to buy that house, they have a car, they have money in the bank, jewelry, wedding ring, starting that retirement. If you haven't started yet, you've got to start retiring, put some money away, save that, not start retiring, start saving for retirement. If you're very lucky, you might have some mineral rights that you're cashing in on. That'd be a nice thing. I'm not going to ask you to raise your hands. You keep that quiet and private. That's fine. Go to the next slide.
Can I make one comment about the 401k?
Sure.
I learned through my husband's account from many moons ago with ARCO, there are some accounts or some companies, that will not transfer any, say he dies, and I die or whatever, I assumed everything would go to Remsen and Ian, but with that particular company, they don't do beneficiary after the wife. And so he had a choice. You either roll all that money now into a different company that will do that, which I had never heard of that. And we just so happened to have a meeting with our TIAA CREP through Southwest Research that day when this man said it. And I said, are you saying, what happens to that money? He goes, we'll dissolve of it back into the company. And I was like, what? And so then the financial advisor's like,
That was some type of company-driven retirement?
you have to be careful, ask your company and make sure they have a beneficiary that's allotted for that 401 or that IRA, because there are some companies that don't. They'll take the money back if you and your wife die. And
So that's more of a,
cash
that's a
benefits.
caveat for that particular company.
It is,
It's
and
not the
so
norm, but
It isn't the norm,
you should,
so we didn't think to ask, it just came up in conversation, and I picked up on, what did you just say? And he's like, oh, we'll just dissolve. I have 2 children, he said, oh, it won't go to them, they don't do beneficiaries.
thanks for sharing that, because I hadn't heard of that
I was
before
like,
either.
what? So we had to transfer it into another IRA with a different company for them to get that.
I haven't heard of that.
Gosh, yeah,
So,
it's pretty sad.
so Bob, going down through life, gets into a really bad accident, and he becomes incapacitated. And he can no longer take care of his own affairs. He didn't plan for any kind of disability. So Mary, as a wife, can make medical decisions for him, but she cannot make financial decisions for him. So all the 50% community interest that he owns in the marital estate, she can't manage most of that without becoming his legal guardian. That's a court process, which on the next slide we're going to see what that looks like. Guardianship happens in probate court. You've got to hire an attorney. It's not something you can do by yourself. The wife, Mary, she would have to apply to become a guardian. She has to get a doctor to evaluate husband first and report that to the court. There's an ad litem attorney that represents the husband. There's the attorney that represents her. There's filing fees of at least $500, and the ad litem attorney's fees have to be paid. Her attorney's fees have to be paid. What else has to happen? She has to go through fingerprinting, background check, and a course, an education course to become certified. Everybody does. And that's to help guardians do their job better and prevent problems. But it's going to cost at least $6,000 just to set it up. Most of the time it's going to cost more than that. I had one ad litem on a case, was already charging $2,500 when I was thinking it was $5,000 or $6,000, but he was just getting started at $2,500. And so that case was probably going to be $10,000, $15,000, or $20,000 to establish a guardianship. And then it takes a few months to get it set up. And what that means is now the judge is monitoring and supervising all the actions of Mary, the guardian. She cannot do anything on her own without first getting permission from the courthouse. So that's where the attorney's fees will drum up, because every time you need action, you need to file a motion, get a hearing, get an order, and then report it back. And then report back to the court what you did. And annually, you got to report to the court on the welfare and on the financial accounting of what you've done. Have I gotten the point across that it's a pain in the rear? So the very easy, simple solution is the DPOA and the MPOA, those two POAs. For a few $100s, you can avoid all of that. Next slide. There. If we're going to be a good steward of what God's given us, of what you have in front of you, plan for the disability with powers of attorney and sometimes health insurance, cancer insurance, long-term care insurance. That's also helpful. Short-term disability, long-term disability, there's a whole host of things you can do to help for disability planning. AFLAC, isn't that one of them? All right, so you can go to the next slide. What are the most common estate planning plans for illness or incapacity? Well, generally, what's the most common estate plan that people do? Actually, I just put the wrong question up there. That's what it was. Bad question. What can we do to plan for incapacity? The POAs, a trust, the directive to physician or the living will that we were just talking about, and sometimes owning assets together. So if Bob and Mary had owned banking together, she could manage the banking. If she owned the investment account together, she can manage that investment account. The trouble is they really can't own everything they have together unless it's all in a trust. Then you can accomplish owning everything together. But normally outside of a trust, there's a limit to what you can jointly own together and still have rights on it, management of it. So we go to the next slide. Medical power of attorney. Do you guys have a good idea of what that might cover? Somebody, when you can't make the decision, now you have an agent who tells the doctors what to do. That's essentially what we're doing.
Sam, question on that. Can you have two different people, one with the power, financial?
Yes.
And also medical? Can you have two different?
You can. If it makes sense in your situation to do that, then yes. If somebody's better with money and somebody's better with doctors, a lot of families do that. You can also have co-agents. You can have one or two or three people making, probably two, I'd go two max, as co-agents for the financial and the medical. Because, you got 9 kids, why put all the burden on one? Put it together and let them help you. Ricky.
Okay, so that first one.
The durable power does not cover medical.
Correct. So the next slide, if we can go to that one, that's the durable power of attorney. That deals with finances, legal matters. Any business type transaction, that's the DPOA. If one of my kids are listening, can you hear me in the back, Mallory? Can you have one of them bring me a water? Okay. Durable power of attorney deals with any kind of business transaction, just about. And if you have that and the other, you stay out of guardianship proceedings. Now, here's something to know. If you have already lost your capacity, do you think that that person can sign a POA into place? No. You have to have capacity to sign these things. So if you've waited too long and you now have stage 4 Alzheimer's, it's too late. Your family now has to go through guardianship for you. I'll share one story. Yeah, I can make it quick. I'll share one story without mentioning names, but I had a fella who I've seen at church over the years. He came in to see me, and he's married, and he informed me in our consultation that his wife had a stroke 15 years before, and she has had short-term memory loss ever since. You tell her something now, about 5 minutes later, you got to tell her again. And he's been taking care of her without any powers of attorney for 16 years. And I'm asking, how can you do that? Like, they refinanced their house, they bought a car, they done business transactions without powers of attorney. The how is nobody knows. The banker didn't know, the car salesman didn't know, and if she trusts him, and she does, whatever he says, she'll sign it. Yeah, sure, whatever he says, yeah, let's do that. So you can kind of go along, or you can appear to have capacity in a short meeting. We, on the other side, can't determine your capacity in a 30-minute, 1 hour. We typically can't. But if you tell us, like he told me, I told him, sadly, I think what's going to happen for him is at some point he's not going to be able to get business done for her. She'll deteriorate to a point where she doesn't trust him or doesn't know him or is combative, or it'll come out that she couldn't remember what the banker just said, and he'll have to go get a guardianship. And it was very sad for me to think that this poor guy is going to have to go through guardianship for his wife anyway, it's just so sad. And I guess he didn't know. He didn't know any different. He didn't know any better 16 years ago or something. But it's a sad situation because it's going to be expensive. And that'll be a hardship for him. We go to the next slide. Living will, we've talked about that. And that is another type of medical form, but it deals with the end of life. The final moments or weeks or months of life, and you're directing on paper when the doctors should stop treatment or withhold it, or certain things you want or don't want. I have some people who don't want to have a feeding tube ever put in, so they write that down. I don't want a feeding tube. Some people want IV fluids. I generally recommend you should have fluids. But the state of Texas form will say no fluids, no IV, no tubes of any kind. So you're going to be losing your hydration, or you're losing your food. And so it's not going to be exactly the illness that's taking you. It's probably going to be a combination of that with starving and dehydrating. So from a Christian perspective and the Baptist perspective, food and water are ordinary care, not medical care. It's what you give your pet, your child, yourself every day. It's what you give the patient in the hospital. It's not medical care that should be denied. It's generally something that should be provided, even if it's through IV tube or feeding tube. So most people don't know some of the details of what the church or faith might instruct, but I thought I'd share that with you, and it's on the slide that you have. So we go to the next page. That's the slide that I printed for you. It's too small to read it up there, so I printed it out for you. There is a document called Will to Live. Have you ever heard of the Will to Live that the SBC has published, or National Right to Life of Texas has published? It's sort of, I saw it. It's in an article I wrote. I don't use it, but because it requires you to kind of pencil in the preferences that you have. And I produce a form that's already written. You don't have to pencil things in. But there is a form that the SBC encourages Baptists to use. It's called a Will to Live. And it is both the medical POA and the living will together in one form.
Sam, if you don't have any of this medical signatures and all in order, like a living will, and that person comes to the very end,
Uh-huh.
would they make that point?
Would make that decision.
When they don't have these papers all in order, it would then be up to the POA to decide to give them this, to keep them living, right?
If you don't have the living will, but you have a medical POA, that person can decide. But if you don't have a medical POA either, then it's the next of kin.
Oh, next of kin has to
Yeah.
make that
Yeah.
decision. Oh, okay, thank you.
Next slide. Other useful tools is a general HIPAA release authorization. So you permit certain people to get all kind of medical information on you. That's a general form. You kind of sign them, individual ones at each doctor's office. You sign one. But there's a general one you can sign. Long-term care insurance is very, very helpful. If you know agents who sell it, talk to that agent and find out what it might cost you. The best time to get it is by the age of 50. 50. If you're 50 to 55, you should be calling that long-term agent because by 55 to 60, your chances of getting it are less and the cost of it's higher. And if you wait till 60 to 65, you maybe have a third chance of getting it, 1/3 chance of getting covered. So there you go. Is it cold in here? It's cold in here now. I feel the wind of God blowing over here. Well, his warm air, right? But I'm feeling cold here. Long-term care insurance. Out of hospital, do not resuscitate order. Do not resuscitate means I'm not breathing. My heart's not beating. That's the equivalent of being dead. So if I had to fall over here and die right now, and I have a do not resuscitate order signed by my doctor, none of you are supposed to apply CPR on me. Then you're going to apply CPR on me. All right, so very important thing, the person has to know about the order. So standard of care is to revive and resuscitate. But if the EMS knows about it, it's in your file, it's on your fridge, it's on your wrist, it's in your pendant, bracelets, tattooed, then DNR, they'll leave you alone, or supposed to anyway. Out of hospital. So when you go in for a surgery, you're going into hospital. You get to make all those decisions and determinations when you go in, but this is for everyday life outside of the hospital. I don't recommend it for everybody. Really, it's not one of the basics 3. It's for certain people who are ready to die and stay dead, okay, and not be brought back. Most of us here probably would want to be resuscitated if they could do it. So that's more for someone who's very sick or very elderly and they're ready to meet their maker. But a lot of people confuse DNR with living will all the time. DNR means you're dead and don't bring me back. Living will means I'm alive, don't treat me anymore, or treat me this way or that way. So just to clarify, a lot of people confuse the two. Designate a guardian. So if you have children are minors, they can't sign powers of attorney. And if you're gone, who are their guardians? Who take them over? So you can designate to the court your wish on who should manage those children. And you cannot escape going to the court and getting court orders over the minor children. You've got to go through that guardianship procedure when you leave behind minor children and grandma's going to take them in. On the estate that you leave behind, if you set up a trust in your will or in your trust, you can set up a minor's trust. You can at least avoid guardianship over the estate of the children, but you cannot avoid guardianship over the body of the child, the welfare, the custody of the child. You have to do that. So all this is saying is, Judge, I would like my friend to be or my sister to be the guardian of my kids. Organ donation, body donation. So organ donation is perfectly licit. The Southern Baptist Convention says it's up to the individual conscience. It's up to the individual Baptist. It's fine. It's an unselfish gift to preserve life. The selling of organs, that's an ethical problem. But the gifting of organs, if you have an extra one, or if you're dying, that's fine. But if you give your only heart away, that's not good, right? Because then you're dead. So you can give away doubles, right? Extra organs. Next slide. Body donation, kind of a weird topic, but some people will want to benefit research. So your doctors, they practice surgery on cadavers, and if you want to be one of those test cadavers, you can donate your body. I wouldn't do that, but some people, rarely, some people will want to do that. Okay, Bob dies. I got to talk faster. Bob dies, and he has a will that he got on his own from the internet or some Office Depot or something. And the court invalidates it because oftentimes those are the worst things for you to do. And most of the time they don't work in court. So I don't know why they sell them. And I don't know why people buy them. I know why people buy them because it's cheap. But don't buy them because most of the time they don't work or you don't fill them out correctly. So one of my very first clients, like 13 years ago, he was rich by my standards. He was rich. And he had done it own, but he filled it out wrong. He had his wife sign as a witness on the will. That's a no-no. There was no notary even on the will, no signed notary or no signature. There was something missing like that too. So it wouldn't have worked for him, but he had thought for 15 years of having it. He thought he had a will. So the next slide tells you, you can be cheap or you can get it right. My first tagline when I was starting was going to be plan or pay. Plan now or pay more later. Because you either pay now or pay more later. Maybe that's what it was going to be. But you have to get the right kind of advice. Okay? And you don't want to necessarily be cheap on the ones you're leaving behind. Don't leave them a mess to clean up. Next slide. Software. Sometimes it works. Sometimes it's good. I'm not going to nix it all. But when it comes to wills and trust, I'm going to say don't go with it. Medical power of attorney, probably fine. Declaration of guardian, maybe fine. A deed here and there, maybe. LLCs, probably okay. But on a lot of things, not enough, not good enough. Next slide. Even the AI is not quite there yet, okay? If you're wondering, can AI take place? Probably not there yet. Maybe in a few years, I'm out of a job. I don't know, but hope not. Hopefully, there's still people who appreciate good old-fashioned legal advice one-on-one. You know, I think there's going to still be people like that. Texas plan. So he's dying. His will's no good. We got to go through probate. Probate is the legal process to figure out what do you have, who do you leave behind, what are your debts, who's in charge of all of that, and then transferring title from dead to living. That's the probate process. It's transparent. Mostly it's transparent. There's a procedure for it. And so you can avoid probate by doing certain actions. We've talked about a lot of that already. Big myth is I have a will, I don't need court, and we mentioned that already. So we'll go to the next slide. It's a lot like guardianship in that you have to hire an attorney most of the time. You have to hire an attorney. Pay court filing fees. It's $500 just to file a case. You got published in the newspaper, which is anywhere from $100 to $150. $100 in Bexar County, $150 and up in Seguin or New Braunfels. And those are required notices and filings. And then the lawyer cost. The lawyer cost can be as low as $3,000 from husband to wife, spouse to spouse. That's using a certain kind of probate procedure. But typically it's going to be $5,000 or more for the normal probating of a will when the last old person dies and now the kids are inheriting. Then it's going to be $5,000 or more. And if you're fighting over things, then it's going to be $20,000, $50,000, $100,000 or more when you're fighting. And we try to do as much as we can to avoid that fighting. You need to do as much as you can to avoid the fighting, but sometimes there's that one person, they're the problem, and they create problem for everybody else. Next slide. And it takes about 3 to 6 months to probate a will in court. 3 to 6 months to finish with the court stuff. But you still have all the executor stuff that you have to do. Selling a house, selling a car, distributing money, closing accounts, filing insurance claim, all that paperwork, funeral home stuff. That can take more time. These are all the different types of probate procedures that the Estates Code permits. Affidavit of heirship is what we use when somebody dies with no will and they have real estate that needs to be determined. And sometimes we do that often, actually. We do that often because it's good enough. It works. Even if you have a will, we'll sometimes use the affidavit. It's cheaper. And it's shorter. But if you have a blended family, stepkids, kids from the other relationship, that's not what you want to do. You don't want that, because not if you're the surviving spouse. You don't want that. We'll go to the next slide. Yes, don't go it on your own. There's certain things. That's why we go to law school. We learn the things. We study the things. The laws change, and I've heard so many kind of common wisdoms shared from people that see me. I heard this and I heard that. And so I'm doing a lot of dispelling of myths. So seek out the counsel of an attorney. Often it's not going to cost you anything to talk to an attorney. So spend an hour, learn something. Actually, you're spending 2 hours, but you can get a free consultation with most attorneys. So spend some time talking. Next slide. Okay, so Bob was in the envious position of having real estate outside of another real estate is what I'm trying to say, but this one's on the ocean in California. Cheap or expensive? So very valuable. So we go to the next slide and we realize that Mary realizes she's got to do probate in California. In California, and that's not the only state that does it, but there are statutorily required fees for the attorney. So on a $1 million estate, that attorney has the right and the client has to pay $23,000. That home is more than $1 million. It's probably $3 or $4 million. So that attorney is going to get about $100,000 just on the home alone. In Texas, we're going to get $3,000 to $5,000 as attorneys. So I do not have plans to move to California, but I've thought about it. When I see this slide, I think about it. We can go to the next slide. So if you have real estate in other states, you really need to consider a living trust in order to streamline and avoid probating in the 2 places or 3 places. Timeshares are considered real estate. So if you have that timeshare in Florida or Nevada or wherever it might, South Carolina, you need to deal with that real estate. Sometimes it's with a trust. Many times people regret they bought it, so they don't want to deal with it at all. They'll leave it, go by the wayside, and that's fine. Next slide. What about Mary? She's so busy dealing with Bob and all that she had to do there, she didn't take time to get her own estate in order. So on the next slide, we learn that she inherited $6 million from Aunt Florence in New York, and she's completely shocked and has a heart attack. She does get resuscitated, but she is incapacitated. Can we go to the next? She's incapacitated, so what do we got to do for her? We have no POA or DPOA. We have $6 million, all her other estate, and the California home has to be managed. So we have to go to guardianship court for that. So a repeat of that. Except this time, she's not the guardian. The next slide is going to tell us who the guardian might be. One of them. Next of kin. The children are the next in order. There's a ranking or a hierarchy of who may serve as guardian. And the court's first going to look to the 3 children. Who's the first one to show up in court and ask for permission? Tom just has to put on a nice suit and tie, comb his hair, and he presents well. It's up to Steve and Julie to come forward to the judge and say, Tom's not the best suitable guy to do this, Judge. We need to get somebody else. And sometimes the unsuitable guy gets all the way through the process, sometimes. But this is where she could have declared who her guardian could be. She could have picked Stephen or Julie to be and not Tom. She could have excluded Tom. But she didn't get to do that. So the next slide, I mean, that's just to tell you it could get worse. Plan. In the next slide, then she dies. She did not have a will, so what do we got to do? Court. Well, first we talk to the lawyer. Find out if we can use an affidavit of heirship or we've got to go to court. In her situation, we have to go to court. All these different assets are out there. So, by the way, that's Jimmy Carter's coffin in, where did he go? Where did he live? Georgia, right? Georgia. Okay, next slide. Same deal. We go through court and we go on to the next slide. But she's got, so the question is on the estate taxes, that $14 million question, the larger estates have to face this estate tax question. So that's part of the lawyer guidance, is delving into that, seeing if it's an issue and how do we avoid taxes and how do we set up the planning. We go to the next slide, and I just want to imagine if she had, let's imagine she had $16 million of estate. The California home's a lot. She inherited $6 million. Adkins home values are going up and up and up, so maybe she gets to $16 million. She's exempt on $14 million of it, right? If she was married still, she could give everything to her spouse, unlimited marital deduction, but that's not the case here. Bob's gone. If she had left money to charity, to Salem Sayers Baptist Church in her will or trust, she could have left $2, $3, $4 million, got under that $14 million mark, and wouldn't have to worry about filing a return. But she didn't, because you can leave everything to the charities, and but she didn't do that. So we imagine she has $2 million of a taxable estate. I calculated the taxes on that amount, and it's $745,000 Uncle Sam's going to waste on the next spending, right? So we go to the next slide. So I would normally say that $14 million amount was going to go down to $7 million at the end of this year. But you heard of the one big, beautiful bill that passed. Part of that was not letting that amount go down, letting it stay at 14 and let it keep climbing over time. And so it made that 10-year, Trump's first act in the first term was giving us these higher numbers. And that was going to sunset at the end of this year. Well, not anymore. Now it's made permanent. So we don't have to worry about her. Well, actually, if she dies this year, she's got $2 million taxable, right? All right, we'll go to the next slide. Mary's problems with the government Texas plan, which was the estates code, the business code, the family code. She didn't get to direct the management of Tom's $3 million. Her real estate is, her real actual worth was $9 million, not $16 million. So a third of 9 is $3 million, right? She didn't get to direct for Tom how he could spend his $3 million. So Tom's going to get $3 million. He's probably going to blow through a big chunk of it. She didn't get to give to the church like she had always intended to. So the church now can't pay for that extension or that capital project like it was hoping. You know, she'd been talking to Pastor Brett for a long time about giving him the money. She didn't actually do it. So now he's got to talk to Steve and Julie about getting that donation. And it's up to them. So certain wishes that she had in mind just don't take place. That's what happens because she didn't plan. Next slide. The next slide. With proper planning, she could have avoided guardianship, avoided probate, avoided estate and gift taxes, and on the next slide, she could have managed for Tom, honored her wishes, prepared for disability, and made a whole lot less problem and trouble for the family. Right? You see that now? So we're going to go to the next slide. And we're going to take a quick break because you might have to stretch or use the facilities. You might want to get a few more grapes or an orange or something and come on back in. Take like 2, 3 minutes, 4 minutes to get up, stretch, and come back. And this is the short half. Okay, we'll finish on time. During the break, if you're interested in signing up for an appointment with my office, it's a free consultation because you've come to a seminar. There's little half sheets on the back table. You can sign those and leave them with Cherokee or with myself, and we will call you to schedule an appointment in the coming months. Schertz Parkway, about 15, 20 minutes from here.
Are there copies of these slides?
I do not have copies of the slides available. It's a big file. It's a big data file.
Were you ever with Cimarron?
That's me.
I met with you.
I know. You look familiar. You look familiar. What's the name? Laura. Yeah. What's your last name?
Buchanan.
Buchanan, yes. That's a while ago.
You look familiar, but then I thought, I remember Cimarron.
I had brown hair, now I have gray hair.
Well, you weren't married back then either.
Oh,
Now you have 3 kids.
that was 9+ years ago. Wow. Are you from around here?
I wasn't sure because I was selling my mom's property. That's what you and I had met about.
Uh-huh.
My mom's property, but yes, I live in Lavernia.
Ah, you're blessed.
Well, I have to sell.
Okay.
My late husband passed 4 years ago, and his daughter doesn't want anything to do with it, so I didn't have to take ownership. I got the letters of administration, and we wrote up that thing. And I'm wondering now, the next steps. They came and took pictures of my house yesterday, so I need to get all my paperwork together. And do I just take it to the title company? Is that what I told you?
Is the lawyer still helping you with it all?
I can reach out to him. I mean, I thought it was all set, that I would just need.
Yeah, what you do is when you have a contract, you give that to the title company. They do title research. They figure out who owns the property. If you have the affidavit or the quitclaim or whatever, they look at that, make sure it's on file, and they will spit back an opinion that says you are the full owner or you and stepdaughter are the full owner or whatever the case is. Those would now become the sellers, right? And then you sell it, and the title will pay out to the right people. If it pays out all to you, and then you're supposed to share with the girl,
No, she, yeah.
or she gave up her rights.
She, in that letter, I mean, it had been established all along. She knew what her father's wishes were, that it was all mine. I mean, she was
Okay, if you can hear the voice, please come on back. Make your way back to this auditorium. Only have 1 more hour left. Just kidding. Just kidding. So during intermission, I had some questions on the slide talking about just imagining what $745,000 going to Uncle Sam, what could that have done for the charities that she cared about? And for the Salem Sayers folks here, what could it have done in your church? Could have done quite a bit. Do you have projects you're working on that you want to fund? There's always projects, there's always maintenance, there's always a new HVAC, new roof, driveway repair, there's always something to fix. $750,000 would have gone a long way. Even $50,000 it helps, $10,000 helps, so whatever people can do. But let's go to the next slide. I pulled a couple pictures off of your school site, the church site. So the other ones is foreign mission work. Charitable giving is going to help the charities so much. And they rely on it. They can't do much of their work without the donations. So I always, again, if you've got an estate plan and you haven't put any charitable giving in it yet, maybe it's time to make an amendment, make a change. So we go to the next slide. Well, it makes me feel good. It makes people feel very good. It's also, I don't think it's necessarily an issue of obedience, because if you've been tithing during lifetime, this is the 90% left over. So it's not like you're obligated to give any more. But if you want to make that extra offering and gift, it feels good. You know you're doing a lot of good with it. And one point was, who will do more to build up the kingdom of God with $3 million? Tom or the church? And that's an easy answer. And so Tom, maybe Mary and Bob did all they could during life for Tom, but they can decide to not leave him very much because they know what he's going to do with it. So redivert that, do more good kingdom building work with those funds. Next slide. Bequest language. It's as simple as saying I give and bequest X amount or X percentage to Salem Sayers Baptist Church or Academy for its general purposes. Leave it unrestricted, perhaps. Next. So, the most common estate plans that I see for death is no plan or the government plan. That's the most common. Wills is another one. If people have thought about it, visited, done any legal work, they've usually done a will. And then rights of survivorship or beneficiary designations they've done at the bank or insurance, so they've done an incomplete part, incomplete planning. But more and more people are asking about trust, and I do a lot of trust work in my office. Probably 3/4 of the people I help with a trust. If they have wills, I help by adding in a right of survivorship agreement for married couples. That's going to make sure that husband's half goes to wife when he dies without going to court.
Well, Sam, are trusts really good to have? Would you recommend trusts to anyone to go that route?
I recommend it. I usually present both options to people. This is what wills look like and how we might avoid probate using wills and other instruments. And this is how we can avoid probate using trusts. I always present them both and then let people choose. And when you hear both of the options, trust usually sounds a bit better. It's more convenient. It's a one-stop planning thing versus a two-stage planning thing. It's a little more expensive than wills on the front end, but it's a lot cheaper on the back end when we die. So most people are choosing trust these days. So yeah, I would recommend it for a lot of people. I don't push it or try to sell it. I just present it, and then you pick what you're more comfortable with. It's like, do you like driving the fancy SUV, or do you like driving the small coupe? You remember Geo Metro, that old little, like, you want the Geo Metro, that'll get you there, or do you want the four-door sedan, and it'll get you there too? So the trust does a little bit more for you. Next slide. Option 1 is you don't do anything, and we leave it up to the government's laws and courts, and we've talked about that. Plan now, or your family will pay for it later, pay more for it later. So I did put that in, I guess on the last, okay, go ahead. Option 2, rights of survivorship. Joint accounts, let's talk about husband and wife, I'm okay with. Parent and child, I see that a lot. Parents will add their child on an account and put right of survivorship, thinking if anything happens to me, my daughter has rights. They can go in and spend the money and they can pay for things. And so I get it. You're looking for that easy transition. If you only had one daughter, that's probably okay. But if you have 9 kids, 7 kids, 3 kids, and you only put one daughter on the account, you just froze out all the other kids. They don't get any portion of that unless your daughter is very generous and shares. That's one thing to think about. If you're going to name POD or right of survivorship, might be inclusive of all the children you want to help. Not the Toms per se, but Steve and Julie probably would be both on there. Even so, I still don't recommend it as a general rule for adult parents to add their children onto their accounts, because your children are out there driving the streets and they can get into a car accident and hurt somebody, and they can get sued, and now your accounts, which they co-own with you, are now subject to the suit over there. So you're putting your assets at jeopardy and at risk for the actions of somebody other than you. You love your daughter, but you don't want your assets to go to your daughter's creditors, right? So that's it's a risk. It's a risk that you're putting your assets in. And so I would recommend that you take family members off of those joint accounts, sign powers of attorney, and with powers of attorney, they can access your accounts during your lifetime when you need the help. You can name them as a convenience signer so they can manage accounts again, during your lifetime without the POA. But at your death, if it's not going to a trust or it's not going to all the kids, sometimes family can still use your money after you die. Sometimes, like the checkbook, the debit card, the ATM, or you're in the last final days, they can go move money around if they have to. But otherwise, those accounts will get frozen at your death. They got to wait for the funeral in about 2 or 3 weeks to get the death certificate. Now they can go get the money. So if your kids can deal with 2 or 3 weeks of waiting before they can get that bank money, that's what I'm saying. That's fine. Maybe you have a special funeral account that you will put a kid on as right of survivorship, $15,000, $20,000, but not leave the bulk of your money that way. Expose $10,000 or $15,000 because it's your funeral plan, that's your final expense account, put the kid on that account, that's fine, I'm okay with that. I just don't like exposing all your monies, like I've said. So that's kind of how I would tell people.
Along with that, you're saying it's not good, say it's one parent living, and then you say you have just 2 children. It's not wise to put one on your checking account, because in the event you cannot sign, they would be able to sign a check for you if you need.
They can still access your money using a power of attorney or convenient signer designation. So there's a way for them to have access to your money without owning your money.
So it's best not to have their name on your checking account as well.
As an owner, yes, as an owner. I don't want them to own your money. I want them to have access to your money. Part of planning for incapacity is making arrangements for people to have access to your assets to pay your bills, right?
Yes, yes.
So I'm not saying don't give them access. I'm saying don't give them ownership during your life. Don't give them ownership. Give them access. They'll get ownership when you die.
Right.
What a lot of parents tell me is, well, I want them to have money to pay the funeral home when I die. I want them to have immediate access to the money. I don't want them to have to wait 2 to 3 weeks for a death certificate. Okay, designate one account. Don't designate $500,000 for the funeral fund because you don't need it for that, okay? Just 10 or 15. Rights of survivorship for husbands and wives. There's a survivorship agreement that husbands and wives can sign that at least helps you to avoid probate on the first death. It only will address your community property, not your separate property. So a lot of farms and ranches might have been inherited, making them separate property of one spouse. This survivor agreement doesn't help get that to the survivor, but a ladybird deed would, or a trust would, or an agreement between spouses saying, you know what, this was separate, we're going to make it community. We agree to make it community. If you're willing to do that, there's an agreement we can sign where you convert the property. And then the survivor agreement would work.
What if the deed they added their spouse to the deed when it was first inherited?
Go to the next slide, and to answer that question, if they did it right, then it's community property. If they didn't do it right, it's only 50% separate and 50% separate. So that might not have fixed it. I've seen a lot of people just add a spouse's name, and it's now just 50% separate.
Well, what happened was that when they died, it was like the lawyer went around and said, who wants to add their spouse to the new deed now that your parents are gone? And some spouses said, yes, add my spouse, and other spouses said, or other siblings
Yeah.
said no.
It's just, if it was done right, then it could have worked out just fine. But wills. Wills are that basic, one of the 3 basic documents. Everybody should have a will, even if you don't plan on probating it when you die. Like my grandma didn't have much. But had she died in a car accident, the only person that can call Thomas J. Henry to sue the bad guy is the executor of the will. So even though she didn't own any much of earthly possessions, after she died, there could be a lawsuit that needs to be prosecuted. Only an executor can do that. The trust can't do it. Only the will probate executor can do it. So everyone should have it. If you're a young person, you see in the news all these attacks in Washington, D.C., and Chicago, and Boston, and everywhere. People are getting beat up and attacked and knifed and kidnapped. And that's going to lead to some type of civil suit against that person's family. If they die from it, we need a will. A lot of personal, yeah. So wills, you need them. I just try to not use them. I try to help you not use them, but you still need them. Next slide talks about the trust. There's so much interest in a living trust. People have misunderstandings or questions, and so I just want to kind of simplify it if I can, and that is having a trust is an arrangement that you put together. It's a written agreement, much like a written will is a type of an agreement. But the key is that your trust that you create is supposed to own the property that you have. So on the next slide, if you would show that, the trust is in the middle. You on the top are creating it. And you on the bottom, you're the beneficiary. So it's all for you. It's your property. You build the trust. You benefit from the trust. You manage the trust. It's all about you. You're not giving it away to a third party. A lot of people think, I'm giving up control. You're not. It's still you in control. What you're doing is transferring title or ownership of assets you have to the name of your trust, which you control, right? So when you die, you don't own assets in your individual name anymore because you gave them to your trust. And when you die, your trust does not die. It's not a human person, so it doesn't die. Your trust still exists, owning all your assets. And if you've done it right, you've put everything in there that should go in there, it owns your stuff. And so then when you die, there's no reason to go probate the will in court because there's nothing to transfer. You already transferred it during your lifetime. They call it a living will trust because you're doing it during your lifetime. So you already transferred assets during your lifetime. Nothing to transfer when you're dead. So no reason to go to probate court. That's how it avoids probate. Does that make sense? It's as simple as that. I set up my trust to own my things that I will manage for the rest of my life, for my benefit the rest of my life. When I die, no court needed. Now it has to go out of the trust to my children. And so your one of the children you picked or two of the children you picked is the trustee now at that time, and they're in charge of dividing everything up and shipping it out, giving it to the other siblings. And those are the assets that go in. The only type of asset that I would typically leave out of a trust would be retirement money. Qualified retirement monies, IRAs, 401ks, that kind of thing, does not go into a trust. Sometimes your company, if you have an LLC, you're running a company, you have a store, that company can stay in its own LLC. And we just make sure that the company agreement talks about who gets the company when the principal owner dies. Does it sell off? Does it go to the partner? Does it go to the wife? Does it go to the trust? But we just make sure that happens inside of the company agreement rather than putting that into the trust. That's how I typically do it. You can do it. You can throw it into the trust if you like, but I typically leave it as a separate company. And then the next slide, the benefits of a trust is that we avoid probate at death. We now have our assets inside of an arrangement where if I become incapacitated or just need help, I can bring in that co-trustee or that successor trustee, and I can step aside and let them manage things for me. So for somebody with Alzheimer's or with cancer or with just, slowing down in life, they can kind of let somebody else take care of business or help take care of business in the trust. And I tell you, banks are going to deal with trusts. They're going to transact with the trustee every day. They're not always going to transact with your power of attorney person. Lots of powers of attorney run into walls and issues and obstacles when dealing with banks and financial companies. But trustees don't, because by law, they have to do business with trustee. But they don't have to, by law, do business with your power of attorney. So trust can be very helpful managing during your lifetime. That's another good benefit. The wills can't do that for you, but a trust can do that for you. Just like wills and just like other planning, you can save on taxes and you can make those charitable gifts. So there you go. It just streamlines things. There's a lot of benefits to it. And we can go to the next slide. What are the downsides? Because there's always a con or a downside, usually. Here it is. The concept of a trust sounds great. Lots of people like the concept. They buy into the idea, they purchase a trust, we put it together, and they don't fund their trust with their assets completely. They put their home in, they put the cars in, they put a couple bank accounts in, but they forget or they get procrastinating, they get slow, and they don't get everything in there. Now we have probate assets to deal with when they die. So what they were trying to avoid, they didn't, because they didn't follow through. So if you know your personality, we generally know our personality. If we know we don't have good follow through, we're probably not a good candidate for the trust. If we know that we only have 2 weeks before I die, you simply don't have time to put together the trust. You don't have time to make all the changes that need to be made. So if you're not disciplined and you're not going to follow through with the instructions the lawyer gives you, then don't do it. Don't waste your time and money. Okay? Just depend on wills, the survivor agreements, and the other plans that we have and that we can maybe offer. One other downside might be you have a bank. Let's pick on a bank. Let's pick on USAA. Anybody have USAA? Let's pick on your bank. USAA no longer handles trusts. They don't let you have a trust account. Most other banks let you have a trust account. So your checking account, you just retitle it, now it's a trust account. USAA does not do that. So if you got money in a USAA and you have a trust, you got to plan for that USAA account separately and differently. Or you go to a different bank. So some companies don't work with trusts. The online banks, there's more and more online banking. Not all of them deal with a trust. So now we got to make a separate arrangement for that online account. So the Lord is going to help you kind of parcel all that out and make a plan for it all. But you want to consolidate everything into that trust if you can. The other, it's not a con, it's just an inconvenience maybe. Some people have all these auto debits, auto pays, their monthly pensions coming in, Social Security's coming in to this one account. And that bank says you have to close the account and get a new account number for the trust. Somebody's going to say to me, that's a lot of work I got to do. Now I got to call all those people and give them a new account number. And I don't want to do that. Some people say that. So, solution is, fine. Don't do it. Designate your trust as the beneficiary upon death. So the next person can take it, close the account, and put it into a new trust account at your death. That's what that person can do. It's not my recommendation. I do want you to go through the inconvenience. I do want you to update all the account numbers and get that account into the trust. That's what I want you to do. But if you're not going to do that, I give you that other alternative. So the next slide. There's a whole bunch of other kinds of trust. I don't want to get into too many of them. But if you have somebody in your household that you take care of that has special needs, they're on Social Security, supplemental income, disability benefits, Social Security, means tested and income tested. That's what I'm talking about. Any program that is means tested or resource-based income level, you need a special needs trust provision in your will or a standalone one, or you make some other arrangement with one of the siblings or kids to kind of go around that and take care of that special person in your life. Medicaid trust are for those folks that make too much money for Medicaid and they need the Medicaid services. There's a workaround if you make too much money. Not quite the workaround if you have too much money, okay? If you have too much in the bank, you got to spend it down or reallocate it. If you're very wealthy, then you look at an ILIT. If you're somewhat wealthy and you have extra IRA money that you don't really need, then you look at a charitable trust where it's somewhat like an annuity. Your kids get money for some time, and then at the end of the period, the charity gets it. Or you reverse that. The charity gets money for so many years, and at the end of the time, your kids get it. That's a charitable annuity or remainder trust. We'll go to the next slide. Quick review together. Next slide. Because I'm already at 12 o'clock, I realize that, so I'm going to shorten it up. What is a legal estate plan? We've talked about all the different components, and they're listed up there. The POAs, the living wills, the trusts, the wills, LLCs, ladybird deeds, charitable giving, beneficiary designation, marital agreements, property agreements, and on and on. There's so much that's involved, and that's like more on the legal side. There's a whole bunch on the advisor, financial, insurance side. Go to the next slide. That's the non-legal stuff, right? And let's say you're not fancy and you don't have a whole lot of stuff. At least you can get your paperwork organized at home. Get your home organized. Get your filing organized. Make duplicate copies of certain information that others need to know. Because if you die tomorrow and you know that it would be very difficult for your survivors to wade through the stuff in your home, that's not doing them any favor. So it's going to slow them down. I had one grandma lived a granddaughter, her home, but she was a hoarder, and the home was stacked wall to wall, floor to ceiling, every room of the house. And the grandma had said, you can't just throw out any book because I put money and jewelry inside of boxes and books and pages. So you got to check every page before you throw it out. So I don't think they've sold the house yet, and that was like 3 years ago. They're still working their way through all that. So my mom's been doing that process. She's somewhat of a hoarder. She's been doing that for like 15 years. She says, I'm getting my final affairs in order. And every time I walk in the home, there's boxes everywhere in the living room. And she's like, I'm going through that. Don't move it. I know what that is. Don't touch it. And I'm thinking, that's the same stuff that you've been talking. Garage sale. The eternal, I'm going to have a garage sale. News flash. Most of your kids do not want your couch, TV, books, clothing. They don't want it. So if you're not using it, if it's stored in the closet for 10 years, get rid of it. Give it away. Have a big trunk or treasure, whatever it is. Have the big sale at the church. Next slide. There's a whole bunch of probate avoidance tools, prearrangements. We've talked about that. This is the money slide. I didn't print it out. I'm sorry, but you can take a picture. These are the quick free tips, the free money, valuable information. POD designation, TOD designation, right of survivorship, wherever you can, on your vehicle titles that nobody signs. There's a right of survivorship paragraph on the bottom of the title for a husband and wife. Pull it out tonight, sign that tonight, husband and wife. Also sign where it says signature of owner. Nobody signs there, sign that. Businesses, you have to plan for succession of your business. If you have any business owners? Any? We'll pass on that then. If you were shy and didn't raise your hand, just call me. We'll talk about how to plan a succession for your business. Right of survivorship agreements. I use this on all the cars, boats, mobile homes, personal kind of vehicle moving things. You can designate a survivor to get the car, even if you haven't paid it off. You don't have the blue title yet. There's a DMV form you can sign. Nobody knows about it. I give it to everybody every day at every meeting. But it's on the DMV website. Don't do the designate beneficiary form, do the right of survivorship form. There's a reason, I don't go into it, but use the right of survivorship form. Living trust, very convenient, especially if you have property outside of Texas. Transfer on death deed is a lot like a ladybird deed. I didn't get to talk about the Todd very much. I don't prefer the Todd, I prefer the ladybird deed. So if you have a Todd, we can talk about why not. If you don't have that, we can talk about ladybird deed. But it gives your home or your real estate or your farm to somebody on your death. So next slide. Next slide. Next slide. Next slide. Next slide. Thank you. Thank you. I'm out of time, so I had to whip through those other ones. I'm out of time. So what I want to say is, did you get any good information today? Yes. Can you share it with people? What are the 3 basic things you need? A will, DPOA, MPOA, and all those other PODs, ROSs, all that other stuff. Spread the word on that, because there's 2/3 of your neighbors don't have any kind of arrangements like that, or it's incomplete. If you have any questions or want to talk about your situation in person, you can fill out that form, and we'll set up a 1-hour call with you in the coming months, a meeting with you in the coming months. I do meet with folks from St. Hedwig and Lavernia and Adkins and Converse, and so you're right in the area. People zip up the road and they come see me. Anyway, I just want to thank Pastor Brett for inviting me. I want to thank the IT guy for helping in the back, for every other volunteer, the door, Wayne, and you were helping with the food, and the other greeters, and Kendra. Kendra's not here, right? Well, thank you, Kendra, because she helped phones and set things up. And thank you for coming today. I hope I wasn't boring. Was I boring? I always feel like I'm boring. But I'm glad that you get good information out of this. And Charlotte, don't let Erica leave out of here without getting that picture. So I will stay here for just a few minutes, like 15 minutes, for a few questions. There's some food in the back. Please go take some food home. And if you want to help clean up in the kitchen, help my wife, please clean up in the kitchen. But yeah, I think you need to close up the house, right? So I'll give you 15 or so minutes. That's not going to handle everybody, but normally I have more time, but I guess we talked a lot and asked a lot of questions during the time. So anyways, 15 minutes, and I thank you very much. Thank you for coming. Do get all the handouts that are in the back, the checklist, 20-item checklist.